Mark Levin, the radio show host, Landmark Legal Foundation scholar, who sees an opening here to challenge the constitutionality itself of what's going on. Mark joins me on the phone right now. Mark, what are you up to?
Well, here's the problem, Neil. The problem is that the House is very schizophrenic about what it's doing and very devious. Let me explain, because some of this is not well understood. They're going to put a rule out, the slaughter rule. Now, what the slaughter rule basically says, we're going to vote on reconciliation, that is, amendments to the Senate bill, and we're going to deem the Senate bill passed. So they're not going to vote on the Senate bill. They're going to amend the bill that they haven't passed. But that's not all of it. Then what they're going to do, and this is a big problem, is they're going to break out the Senate bill part that they never voted on from the reconciliation part that they did vote on, send that to the president. He's going to sign that and claim that it's the law. So they're going to combine them for the purposes of passing, they say, the Senate bill. They're going to break out the Senate bill and send it to the president, because then it matches up with the Senate, and he's going to sign it. You can't have it both ways, say it's one and the same bill, but now it's not one and the same bill. That's number one. And number two, if they go the reconciliation route, the slaughter bill, the Senate has never voted on the reconciliation bill. So in other words, you have to send a single bill to the president that has the exact language of both bodies. That's what the Constitution compels. And what they're sending to the president is a piece of paper. It's not a bill. It can't be a law. And this clever attempt, what they're hoping is that that the court will not look behind what they're doing, that the court will give deference to Congress, and the court will say, look, we're not going to get into this. This is a political issue. That is the hump we're going to fight. That's the hump we believe we can get over, because we don't believe any House in Congress has ever done this.
But now when Democrats charge that Republicans did this plenty of times on this Deem thing, are they right?
Who cares? Political precedent is not relevant in a courtroom. What a court wants to know is, what is your constitutional argument? Can you match up the constitutional argument with a particular statute or act by a body or an individual? The argument that, hey, they did it too and they did it 50 times has absolutely no relevance. And I would argue that, first of all, they didn't do it 50 times. That people are lumping in all kinds of technical corrections and revenue issues with something that is utterly fundamental. I do.
All right, well, look, if I could just stop you there, Mark, you're a genius with this stuff. Just to bring it back to relate to it, if you were to succeed with this, then it would effectively negate the entire legislation, right?
Well, what we're saying to the judge, and if he doesn't rule with us to the circuit court, if they don't rule with us to the Supreme Court, and by the way, if we win at those levels, the government will go up the chain too, is the president...
You would go up all the way to the Supreme Court?
Well, we would certainly try, and so would the government, if they lose. The point we're going to make is that the president, the attorney general, the HHS secretary, and the Treasury secretary have absolutely no constitutional authority to enforce a non-existent law. So yes, it would stop this, and if Congress wants to pass this law, they have to follow the Constitution. It's really that simple. And they can't get the votes to do it. That's their problem.